All right, this is the judgment. The accused person is charged with the offense of obtaining monies by false pretenses, contrary to Section 313 of the Penal Code, and particular sort of offense being that on the diverse dates between 24th January 2019, 26th March 2021, at Nairobi within the Republic of Kenya with the intent to defraud, obtain 2.4 million from one Isack Nyongesa of Kwara by falsely pretending that you were in a position to construct a residential house for him, a fact you knew was false. I believe you heard all what the witnesses said. I also heard you. Now, Section 313 of the Penal Code states as follows: any person who by any false pretense and with intent to defraud obtains from any other person anything capable of being stolen, or induces any other person to deliver to any person anything capable of being stolen, is guilty of misdemeanor and liable to imprisonment for 3 years. Now, Section 312 of the Penal Code defines what false pretense is. Says, any representation made by words, writing, or conduct of a matter of fact, either past or present, which representation is false in fact, and which the person making it knows to be false or does not believe it to be true, is a false pretense. So the word seems to be applicable in the following instances. 1, representation by words, writing, or conduct. Number 2, representation in either past or present. Number 3, representation that is false. Number 4, a representation made knowing it to be false or believing it not to be true. Courts have times without number dealt with the interpretation of this particular law, and what is coming out in most decision is this offense does not relate to the future, but it only relates to the past and the present. Only in exceptional cases and the material that differ from the rest of the cases can we refer it to the future. Now, the material before the court, there are several issues which are not disputed. Number 1, it is not disputed that the structural agreement limited the works to the first phase of the building. The second phase was not captured in this agreement, so that the contract did not include wiring, fitting, plumbing, paintwork, staircase grills, window panes, balcony grill, among others. Additionally, the breakdown of the monies alleged to have been given to the accused did not include the works that the accused executed. In other words, it's not clear how much went to the materials and the labor and how much went to his professional work. To the contrary, the accused in his defense tabulated the works done against the monies received. No questions were put to him for the purposes of veracity. However, I note that there is also a civil suit running parallel to these proceedings over the same subject matter, and of striking interest is that there is a structural agreement which is at the center of this case. This document was marked as MFI number 5, but was never produced by the state as an exhibit. Instead thereof, it was produced by the accused in his defense. The documents were marked for identification, and other documents were marked for identification, but were also never produced as exhibits. The law is very clear when documents are marked and are not produced. Musau Wambua versus the Republic 2020, together with the case of Kenneth Nyaga Muige versus Austin Kiguta 2015, the court said, in that case, I quote, in the instant case, we are of the view that the failure or omission by the respondent to formally produce the documents marked for identification being MFI 1, 2, and 3 is fatal to the respondent's case. The documents did not become exhibits before the trial court. They were simply marked for identification and they have no evidential weight. This record shows that the trial court relied on the document MFI number 2 that was marked for identification in its analysis of the evidence and determination of the dispute before this court. We are persuaded by the dicta in Nigerian case Michael Ausa versus the state 1994 Supreme Court that a document marked for identification is not part of the evidence that a trial court can use in making its decision. So this document, being at the center of the dispute, was marked and never produced. It laid the face that the construction was to take place, but the complainant chose not to bring it to the attention of the court. It is trade law, therefore, when a star witness creates a doubt in the mind of the court as to the veracity of his testimony, the court will not take his testimony seriously. The second one is, having found that the same subject matter is a subject in civil cases, my question would be, what is it that the complainant was not able to do or is not able to prove in the criminal case, in the civil case, that he can now prove in the current criminal proceedings? Commissioner of Police and Director of DCI versus Kenya Commercial Bank 2013. Court of Appeal said, while the law section 183A of the criminal procedure allows the concurrent litigation of civil and criminal proceedings arising from the same issues, and while it is the prerogative of the police to investigate crime, we reiterate that power must be exercised responsibly in accordance with the laws of the land and in good faith. What is it that the company was not able to do to prove its claim against the bank in the previous proceedings, civil proceedings? That must be done now through the institution of criminal proceedings. It is not in the public interest or in the interest of administration of justice to use criminal processes to subdue parties. Ultimately, a make-a-funny prosecution has failed to prove their case beyond reasonable doubt and acquit the accused person under Section 215 of the CPC. Prosecutor, why are you not saying most obliged? Or you think it just has not been done?